The most notable decision is the Delgamuukw decision in 1997, and that's the one. That's the where this comes from. That's where Aboriginal title really comes from. Now the Delgamuukw case was very I would say radical, because it did a number of things to favor Indigenous land claims. Well, as I understand it, the trial judge in Cowichan gave all of the parties 18 months to enter into some negotiations. What that means, as I interpret it, is the government is supposed to be paying off the Cowichan band. In other words, the Cowichan claimants I don't think, actually want the property or the responsibility of managing the businesses and the city infrastructure. I think what they want is, to put it crudely, money.
Brian Giesbrecht. Brian is a retired lawyer and Manitoba judge, both at the family court level and the criminal court level. Brian is a frequent writer and commentator on Indigenous matters in Canada. And we welcome you to the show, Brian.
Oh, it's good to be here, Bill. Thank you.
The Cowichan decision that was made by the British Columbia Supreme Court recently, that is throwing private landowners in the Cowichan area of BC into a bit of a dither and some panic over their private fee simple land titles. And I believe the court ruling gives preference to the Aboriginal title. Could you give us a little bit of a background legally, a little bit of history on what's going on there?
Yeah, I think the Cowichan decision really caught the attention of the public for the simple reason that it involves land in an urban area. The Supreme Court had actually given rulings similar quite long before the Cowichan decision. There had been some discussions of Aboriginal title before that, such as in the 1973 Calder case, but it was Delgamuukw that really galvanized this, and that's the main precedent that the trial judge in Cowichan would have been using. So Delgamuukw, and then there were a number of cases after that which expanded on what the Supreme Court said in Delgamuukw. And I should mention here, Bill, that I'm not an expert on Aboriginal law at all. Most of what I dealt with in the provincial court were fairly basic cases in child welfare court and criminal court. So I'm not giving some sort of legal analysis of any case. I'm just giving sort of the basic highlights of what these decisions said. Now, the Delgamuukw case was very, I would say, radical, because it did a number of things to favor Indigenous land claims. And for instance, it said that folklore, Indian folklore, what they call oral history, was to be considered reliable evidence. Now, folklore is not reliable evidence, and their decision there to grant Indigenous folklore some sort of magical quality was highly unusual.
Brian, folklore in today's legal terms, that's considered, is it not hearsay evidence?
Well, that's what it is. It's hearsay evidence. And then the Cowichan, jumping ahead to the Cowichan decision, the trial judge had what is hearsay evidence from 1846, and she used that because the Supreme Court had said that was acceptable. Now that's very strange, a very strange thing, and any court in anywhere in the Western world would find that to be very odd. So yes, it's hearsay evidence. So Indians didn't have writing, but basically what the trial judge did is listen to claims from somebody now, today, who was talking about something that supposedly happened or was said in 1846. So that's very unusual.
Well, yeah, and like hearsay evidence, I mean, is a common thing. It will be discussed or entered into many court situations. But unless it's documented and verified with other credible historic, documents or anthropological findings, it doesn't hold much weight in a court where non-Aboriginal matters are being discussed, and this Delgama ruling isn't applying. Is that my reading on it?
Yeah, put it this way, Bill. If you or I went to court and said that our great grandfather told us something in 1846, that would not carry any water at all. That would not be given
Yes.
any weight. But because this was from Indigenous people, the Supreme Court said it had this certain quality that made it reliable. Were similar evidence from any other ethnic group or racial group would not be admissible. So that's one only of the very unusual things about the Delgamuukw decision. But the other one was simply the age of the case. If you or I went into a court and said we wanted to base a claim on something that happened in 1846, we would be told, sorry, but that's far too long ago. You missed your chance. The case should have been brought much closer to when it happened. But in the case of Indigenous claims, they said no. You can still bring the case. The honor of the Crown demands that these claims be allowed. And the third thing that's very unusual, and I don't want to rattle on you here, but the third thing that's very unusual is that they talked about title at all, because you and I know what history of the North American Indian. They didn't have any such thing as titles. They were hunting groups, and the stronger group would hunt in the land that they could control, and until they were driven off by a stronger group yet. So the idea that modern land titles somehow applied to the type of occupancy Indian groups had, that's highly unusual. So I'm not making a defense of the trial judge in Cowichan, but what I'm saying is she was relying on precedent that was set for her by the Supreme Court.
Exactly, and she's compelled to follow the laws that have preceded her case that is in front of her.
Yes, she is, and I have no doubt that when this case eventually gets to the appeal level, some of what she's decided will probably be overturned. I don't know if you've seen Nina Green's extensive research on
Yes.
the historical errors made by the trial judge, but there's no doubt that she made some. But the essential principle of that Delgamuukw case and the line of cases, what I've just discussed, still stands. So unless the Supreme Court is prepared to at least partially reverse itself, we're going to be stuck with an ever increasing list of Aboriginal title cases.
That leads me into the next situation or next question, Brian, is where are we now? There's some kind of an 18-month period of limbo or whatever. What's the status right now, and where are we kind of heading?
Well, as I understand it, the trial judge in Cowichan gave all of the parties 18 months to enter into some negotiations. What that means, as I interpret it, is the government is supposed to be paying off the Cowichan band. In other words, the Cowichan claimants I don't think, actually want the property or the responsibility of managing the businesses and the city infrastructure. I think what they want is, to put it crudely, money. And so basically, the judge is saying to the various levels of government, "All right, you make a deal and pay off these people." So that's, I believe, where we are at right now. Now, whether an appeal court is going to change any of this, we don't know. And as a matter of fact, how vigorously the province or federal government are even going to prosecute their appeals is problematic, because we have, and I don't want to go too deep into the weeds, but we have these practice directives that are now in place, Bill, that basically tell the government lawyers who are looking after these cases, well, if something is going to be offensive to the reconciliation, you can't raise that ground. And we have judges who have been, with the case law, told that the pursuit of reconciliation is supposed to be all important. So, in some sense, on Indigenous claims, the pursuit of justice has been modified to include the pursuit of reconciliation at all costs. And I think that's where we are today.
Yeah, to put it bluntly, it sounds like the Canadian legal system has been hogtied when it comes to these matters.
Well, I would say that this was a legal system and a court that did this to itself. And if you want me to go into a little bit of this history to explain how this happened, I'd be pleased to do that, Bill.
Sure.
Because as I see, say, Indian history in Canada, it's really divided into to two parts. You have two law, and then you had what the Supreme Court did after 1982. And you and I were both around in 1982, and we know what the situation was then. Basically, the expectation was that Indians were going to work their way into Canadian society. That was the whole idea of the Indian Act and the reserve system. It was originally supposed to be temporary and just give Indians a chance to bridge the gap until they were able to enter the modern world. But unfortunately, there have been so many, say, financial modifications, perks, that we still have the reserve system. But until 1982, there was a pretty clear expectation that Indians were Canadian citizens. They have by that time, they had all of the rights in terms of the right to vote and right to run for office, etc. But after 1982, this began to change. What happened in 1982? Mm-hmm. Well, we had constitutional discussions, and the original intent, for instance, was there was no such thing as a special clause about Indian rights. As a matter of fact, what there was, and this was Pierre Trudeau put this forward, we had constitutional protection of private property. That was the idea. That's the bill that's what Trudeau was trying to push, and he gets criticized rightly or wrongly for all kinds of things. But in this one, he was right. We should have had constitutional protection, but for various reasons, and I won't go into it, but some of the premiers objected to that. So Canadians do not have constitutional protection for private property like Americans do. But at the same time, the Indian chiefs lobbied for the inclusion of Section 35, which says Aboriginal rights. Now, that was strongly objected to by, in particular, the premier of my province, Sterling Lyon, as well as Peter Lougheed. They envisaged a situation where we would have an activist Supreme Court that would start inventing new Indian rights. And they refused to sign until the word existing was put in to make it clear that the
Alan
rights
Blakely.
as of 1982, yeah.
Is the
But
Premier of Saskatchewan, Alan Blakely. He was the man, NDP. He pushed that as a, what do you call it? It helped break the deadlock the premiers were in.
that's exactly it. But what happened, and as I say, I'm not going to try to go through the whole timeline of which Supreme. I'll concentrate on Delgamuc, but the Supreme Court, in my opinion, disregarded that very clear uh, um, um, expectation from the premiers and the prime minister who signed the document, and they began to invent brand new Indian rights.
Yes.
We had the duty to consult, and we've seen what that's done. But for our purposes here, Aboriginal title, the idea that an Aboriginal title existed that could actually displace an existing title was a Supreme Court invention. So once again, we have a lot of criticism for some prime ministers like Justin Trudeau, for instance, but he didn't do that. That was
Yes.
the Supreme Court itself that did this. So I should make that clear. But that's where it comes from,
Mm-hmm.
and so we had a steadily expanding group of list of special Indian rights, and the Cowichan case is the most radical example.
Mm-hmm.
And as I say, it's really getting so much attention only because it's not like Delgamuc where you had land way out in the boondocks someplace.
Mm-hmm.
You had land smack dab in the middle
Well,
of Fort Richmond.
yes, and considering that BC is in a province where there's very little land that is considered to be ceded by treaty, this opens up an awful lot of room for these claims. And like I'm looking at a few of the other provinces across the province. We have all of Prince Edward Island, parts of New Brunswick, portions of Ontario, including Ottawa and Quebec, that have unceded territories. So this could literally explode, could it not?
Well, it definitely could, and it is. The history of these uh, cases is that every time the Indigenous claimants get the window opened a little bit more, in other words, where they have a successful result, then you get even more cases, and that's what's happening now. We've even got the Dakota Sioux have launched a case here on the prairies. There are already plans underway to re-examine, even in the treaty areas, Bill.
Mm-hmm.
We have a chief who basically said, the head chief basically said, the treaties aren't worth the paper they're written on.
Yeah.
We want modern treaties based on Aboriginal title concepts. So we have some of the most expensive lawyers in Canada working on these cases, and they're winding their way through their court through the court system. So this is
Brian,
only the beginning.
this is another question. Where is all the funding and the money coming to pay all these highly expensive lawyers that are doing and basically suing provinces and governments? And where is all the money coming from?
Well, basically from the taxpayer. And Francis Widdowson's book, The Aboriginal Industry, or also known as the Indian Industry, is the explanation here. And just to assure you that this is not a racist term on my part. Most of the people in the Indian industry aren't even Indians.
Yes,
they are
they're
lawyers.
very well padded lawyers, activists, consultants, journalists that don't have any indigenous ancestry.
Entire universities and
Yes.
the bureaucracy in Ottawa. And I'm not pointing the finger at any of these people. I mean, they're just doing their job. The
Yeah.
lawyers are taking
Yeah.
on cases because they think they can win them and because they think they can get good fees. So I'm not vilifying these people. I'm
No.
just saying that what we have in Canada is it is an Indian industry that is growing exponentially, and I believe that something has to give here because it's not only becoming incredibly expensive, but Cowichan is a clear example of where it's actually destabilizing the country. Once you interfere with the certainty of property rights, then you're in very dangerous territory because a liberal democracy cannot survive if property rights are not certain. That's something that's taken 1,000 years to develop, and to just throw it all away is extremely unwise.
Your thoughts, just winding up on this topic, Brian. Where do we go? Like, how do we resolve all of this this chaos that we're in?
Well, as you know, some of the members of our group, and I happen to agree with them, say that uh, Section 35 has to go.
Mhm.
We have to, and I think we are sort of winding our way to a ultimate crisis where there are going to have to be constitutional discussions. And in my view, and I've advocated for this for many years, we have to get rid of the entire Indian apartheid system.
Mhm.
As I said, it was never meant to be something that was permanent. It was meant to exist until Indians were able to get on their feet and compete successfully
Mhm.
in the modern economy. But what we have created is really it's a Frankenstein monster because it just keeps going, and it all depends on the taxpayer. The money demands are from people who are not producing wealth; they're just taking wealth. You have Tom Flanagan as a guest pretty soon, and
Coming up,
he's
yeah. We're gonna.
very influential as far as I'm concerned. He's then probably the number one Indigenous issue expert in Canada. And the way he describes it in one of his books is you have um, communities that produce and uh, communities that extract. And unfortunately, most Indian reserves are in that second category where they don't produce wealth. They're simply taking wealth. And eventually that system has to fall. So